Hey everyone, I hope you can hear me. My name is Paula. Welcome to today's session on the GDPR. I was given the green light by the organizers to start a little early. It is great to see that the GDPR remains such a crowd pleaser, though perhaps this is not due to the law, but due to this very distinguished and interdisciplinary panel that we have assembled here. In any case, I'm very grateful to see you here. I'm honored to be chairing this panel. What we thought we'd do is just do a round of introductory remarks, allowing all of our speakers to briefly introduce themselves, followed by a discussion between the panelists. And then, of course, we'd also be very curious to hear your views and questions on the GDPR. Hoping to have a very interactive discussion, despite the fact that I know that there's always a bit of a post-lunch slump, particularly given the extraordinarily delicious food that we receive here. But why don't we kick it off with Gosha, who has a lot of experience actually in EU policymaking, and who will allow us to participate in a round of GDPR myth-busting and EU myth-bustings, amongst others. It reminds me a little bit you know, the day after the UK voted to leave the EU, the most asked question on Google was, what is the EU? So, Gosha, what is the EU? What is the GDPR? And what is it not? Thank you.
Okay, thank you very much for this very kind introduction and the invitation. It's a real honor and pleasure to participate in another event of the ORF. Yes, indeed, I've worked almost for 10 years in Brussels and 8 years in the European Commission, which is the executive body out of, I would say, one of the 6 core institutions. And most of the time I was dealing with the integration of the EU single market, the services, and the institutional level and the international level. So I work a lot with non-EU countries, and last 4 years specifically in the telecommunication and the digital single market, meaning e-commerce, digital trade. I've been participating in the EU negotiations, free trade agreement, let's say, with all non-EU ongoing negotiations, so indeed there is a big scope. I've never worked directly on the GDPR, but I would say it was very important at some stage also in the trade and economic negotiations. We had provisions under the digital trade chapter on data flows with third countries, apart from the adequacy decisions, which some of you might already know. So now the demystification, yes. When you I must say, from all my years, GDPR, probably after roaming agreement, because as you might know, we abolished roaming charges between EU 28 member states. We pay like roam like at home. Basically, you pay your price when you're abroad at the domestic price. So apart from that one, which we also had lots of spokesperson work, we gave lots of spokesperson, yes. The GDPR, I would say, it's maybe even bigger because it's really the global one. And when you are popular, people like to talk about you, right? So not all of it is true. No, it's not always good. And this is also the case of the GDPR and its assessment, because I say it's our celebrity among our regulations. And yeah, so I would say I've noted at least 10 myths or like misinformation, which was in the press and among the people and their fears. I would say a different level of granularity, you know, more or less serious, depends what's important for you. So first of all, GDPR completely changes the way organizations need to handle data, right? But if you can tell me, the EU has had data protection rules since already when? Does anybody know in the room? Okay, so basically the first data protection regulation at the EU level was already introduced in 1995, 20 years ago, almost 25 years ago. So this is not that new as we might think. The EU just had to adjust the rules to the new global area, to the digital century, right? How we operate, how the markets operate, and all disruptive technologies. I would say the myth number 2 is that we need more time to adapt to these complicated rules. Okay, it's a bit retroactive, but I'm like, come on, 2 years is not enough, like especially in these disruptive economies, when you get access to your service over internet with 1 click, with seconds. 2 years is lots of time. So we had the adoption was in May 2016, and countries, authorities had 2 years to implement, so also business had time to follow, you know, and prepare accordingly. And I would say the myth number 3 is that GDPR is overwhelming for small businesses, right? Yes, that's true, but also, no, it's actually false. The obligations are not the same for all companies and organizations. The GDPR is not meant to overburden small and medium enterprises. The obligations are calibrated to the size of the business and or the nature of the data being processed. And you might have the penalty up to 4% of your annual revenue, so it depends, of course, of your revenue per year. And smaller companies processing less data and not processing sensitive data, such as political views or your health records or sexual orientation, will have fewer obligations to follow. For example, not every company has to appoint a famous data protection officer or carry out a data protection impact assessment. Of course, it depends on the scale of your business. And then, of course, there are like many non-economic, non-business obligations for political parties, for journalists, etc. But maybe we talk about it later. One of my favorite ones, the tough one. The fines under GDPR can kill your business. And it's actually linked with the argument number 3. It doesn't mean that the fine would always be 20 million euro, like immediately now. The regulation has many warning mechanisms, and of course there are different, mechanisms, yes, there are different, I would say, proportion, and what we noted so far, already the regulators imposed some penalties, and they might vary from like 5,000 euro penalty, which is not that much, for spotting like cafe in Austria illegally video surveilling you, or it might be 50 million for Google in France because of the conditions for obtaining consent from users, which was not perceived correct, and over 200 million euro on data broker company in Poland, which I'm from Poland, I know the case, for failure to inform individuals that the data was being processed. I'm really annoyed. I pick up the phone when I'm at home and they ask about my data, or they ask me to participate in a survey. I'm like, my first question, who gave you my data? Like, okay, please immediately erase, record. And then I know the name of the company, and I can, of course, complain to my regulator. And this apologize to UK ambassador, but the biggest record, I would say, fine so far is the British Airways. If you heard about the case, very famous in July 2019, it's over 230 million euro, which is 1.5% of the British Airways annual revenue. So as you see, up to 4%, there is still a big, I would say, margin. And the issue is that after website failure compromised the personal details of roughly 500,000 customers. So you see also the scale. It would be the largest penalty yet. And then I think there is a huge potential, yes, I finished. There is a huge potential for cybersecurity, as you see, because there is also I would say, the appeal mechanism, yes? So, so far, the UK Information Commissioner's Office said that the weak security allowed user traffic to be diverted to a fraudulent page starting in June. And of course, many sensitive data like your login, payment details, or travel bookings arrangement were disclosed. But then there is currently the case if it was really the fault of British Airways, or rather the fraud. And then, as I say, it's for the cyber. As you see, there are like many arguments, but I know the time is off and we have lots of time for discussion. So I have some more examples from the private life, but this maybe we can give time later. And then probably as we are in India, I'm sitting, with two colleagues from the US, one representative from the global high-tech giant, yes. So maybe we can also talk a bit about the non-EU companies, because it was not only the EU legislation at some point, as you know, it has become global, and we are also happy in a way in the EU that it was a reference, point of reference to set standards, like a trigger to also facilitate or maybe start discussions in other countries. So that's, yes, that's enough. No, thank you.
Perfect. Thank you so much. I think that was a good introduction to address common misconceptions about the GDPR. And with that, I will hand it over to Anushka, who will give a bit of a global overview with regards to the GDPR's significance and how can we assess this law, its positive impacts, potentially also challenges.
Good afternoon, everybody. Thank you so much, Paula. First of all, thank you to the organizers. This is my second time at Sci-Fi, and I'm more impressed this time than I was last year even. So for me, this is going to be a learning experience, definitely, because I'm glad that we have a panel where there are state representatives, private sector, European Commission, as well as someone from a legal background. Just a very quick note, my name is Anoushka Cossack. I'm heading the cybersecurity policy program for a think tank called GLOBSEC. We're currently based in Bratislava, and we have about 65 people. In addition to cybersecurity, our biggest and most robust programs are defense and security and strategic communications, where we focus a lot on disinformation activities in the region and in the region of Central Europe and abroad. Also, some of you may be familiar with the GLOBSEC Bratislava Forum that we do every summer. So I'll be approaching the topic today from the policy and research side. Now that we're 17 months into the enforcement of the regulation, I do think we're perhaps a little early in terms of being able to evaluate its success in its entirety. I'd like to actually first take a few steps back to reiterate for everybody why the GDPR was so significant and so sort of revolutionary. First, and these points I'll go through quickly and then kind of make my argument after. So the first is obviously its strength lies in it being a data governance framework that almost enforces companies and organizations to really think about store usage and collection of data, and putting in principles like purpose limitation, data minimization, as well as limiting data storage. These are just a handful of provisions. Second, high quality consent. They impose substantive procedural requirements such that consent is specific, unambiguous, and also additionally, a lot of the rules are actually unwaivable even after a data subject has given consent. Third would be institutionalizing accountability. A good example of this would be the relationship between controllers and processors, such that the latter can't subcontract without without kind of the wish of the controller. The third would be, of course, the right to be forgotten, which we've extensively, I think, talked about even during this conference. And then maybe the last would be the provision of data protection by design and by default. So these are, I mean, I think depending on who you ask, they'll have their kind of top 5. These are the best provisions, or these are the most extraordinary provisions that GDPR has. This is my kind of take on it. So how do you actually go about assessing the success of GDPR, which is the point of today's discussion? Depending on the sources that you look at currently, you'll find a number of sources and a lot of data, both collected by the European Union as well as by private sector. So we have Thomson Reuters, we have a lot of consultancies who are now doing these kind of surveys and work on gauging the level of implementation across sectors. So, if we take the barometer of success for the GDPR to be the amount of fines imposed, then until May 2019, it was 56 million. That doesn't include the cases of British Airways and Marriott. If we were to evaluate it based on the number of complaints lodged, again, by May 2019, it was around 100,000. If we take a more qualitative approach, the European Union Fundamental Rights Agency has a study that looks at the impact of GDPR on civil society organizations. Again, lots of statistics there. I won't go into all of them, but one example would be that 77% of that particular sample face challenges on the implementation of the GDPR. On the more positive side, 66% indicated that because of the GDPR, they had an almost expert or fair understanding of EU data protection regulation. Now, if we're feeling a little bit adventurous and a little bit open-minded, we can also look at the infographics that were published by the European Commission, and these are titled GDPR in Numbers. The following is a direct quote. During the peak month of 2018, GDPR was searched more often on Google than American superstars Beyonce and Kim Kardashian. That's just your usual European Commission humor for you, and you have that as well. I think the point that I'm trying to make is that at this stage, 17 months in, it's perhaps easier to assess the normative goals that the GDPR tried to kind of implement, and obviously these include empowering data subjects, instilling this culture of trust and accountability, more than kind of looking at the actual success of all those 99 articles and provisions. The limitations that we face in actually assessing GDPR at this current stage are also inextricably linked to two of the challenges that I perceive when you're implementing GDPR, like two of the main challenges that I perceive. First is the varied and limited capacities of regulatory authorities, both in enforcing that particular regulation, but also in actually being able to support data subjects who want to know more about GDPR and kind of help them in being compliant. And an example from the survey that I mentioned, the EU Fundamental Rights Agency survey, is that nearly 50% indicated that they were not provided assistance when they tried to approach whatever national regulatory authority. In the same point, limited manpower and legal resources are also a consideration. as someone who's working in a think tank in Central Europe, and as someone who's worked with organizations and in organizations in Western Europe, I do see we have to talk about the cultural differences and cultural perceptions of data itself. That is a consideration. I think when we're maybe in India or in other countries outside the EU, we tend to see the European Union as one homogenized continent. That's not the case. A lot of, if you were in Slovakia versus if you were in France, Germany, the perceptions are different, and that has an impact on achieving those normative goals, as well as actually, I'll just wrap up in like 2 minutes, and the implementations of the provisions as well. And the second challenge, obviously, and this has been talked about since we've been talking about the GDPR, is the complexity of provisions across those 99 articles, such that, let's be honest, at this current stage, there are a lot of companies and organizations that are probably not 100% compliant at all times. So how do I see this moving forward? I mean, I'll conclude by saying that currently, I don't think we can successfully assess the GDPR in a vacuum. I think we need to kind of see it in the backdrop of this theater of negotiations between sort of big tech players as well as the European Commission. Also because Margaret Vestager now has that digital agenda, and maybe focus on the consequences of that. But yeah, I would conclude by saying that I think we've been more successful on the normative goals than the actual implementation of the provisions. Thank you.
Thank you so much, Anushka. This is a really helpful introduction also to some of the challenges and diversity of views also on the GDPR and perhaps on even implementation across member states, which I think was also underlying in your comments. But I think another interesting perspective that I'm grateful we also have at the table is from Rob, who is a Vice President and Deputy Chief Privacy Officer at Facebook, who can bring in perhaps a private sector perspective and also a global perspective on the GDPR, working for a large American player in this field.
Absolutely, thank you. And I wanted to spend a couple of minutes maybe talking about this global perspective and what I take away from the GDPR, both in terms of the impact that it's had in Europe and perhaps more importantly for this conversation, the impact that it has had on the global discussion around data protection. And before I get into some of the substantive things that I think are useful as we're talking about data protection legislation here in India, I think one of the things qualitatively that really stands out for me in my career thinking about data protection is GDPR was really a pivot point, not just in Europe but globally, when people were thinking about privacy in a tangible way, both in the policy discussions and in the interactions that we had with businesses that use Facebook as a platform, and just with normal consumers. The kinds of conversations that I was having with business leaders and with consumers who use Facebook, much more focused on privacy and much more concrete in the level of sophistication of what people were focused on than was happened before. So before you even get to the substance of what GDPR requires and what it does from a concrete perspective, I think that's a really positive thing, right? It's positive that companies are thinking more about how to protect data. It's positive that people are thinking about how they want their data to be used. And I think if one goal of data protection legislation is to empower people to make sure that their information is protected, I think it's hard to deny that GDPR has had a positive impact when it comes to that. But turning to some of the substance of what GDPR adds, and what I think are useful, what we see in the Sri Krishna proposal for data protection legislation here in India, and what we see in a lot of proposals, one component is this idea of giving people rights over their data. So moving away from, in the US, for example, we have this concept of notice and choice. We tell people what's going on and they can control it. But actually, GDPR adds the ability to access your data, to delete it, to port it, to correct it. These kinds of things that are sort of both fundamental and universal. And I think the idea of having those basic rights, again, before you get to anything else, is a really compelling aspect of what GDPR added. GDPR also recognizes, and I sort of talked about the fact that there are limits to how effective notice can be, right? So we all, we talked yesterday about the fact that we all have apps on our phone. We're not reading the privacy policies necessarily. We're not making these nuanced judgments about whether we're going to use this app or that app based on its privacy practices. And there's a lot of research that says even if people do read it, that's not actually informing their decision making. And so recognizing that there need to be non-consensual bases of processing, that some things are really important for people to know about and to consent to, and other things are just just consistent with the service that people are providing and don't rise to that same level. So when we prompt people to consent, they're focused on the things that are actually the most significant from a data protection perspective. I think that's also a really important contribution. GDPR recognizes a spectrum when it comes to protecting the privacy of minors, which is also something that we spend a lot of time at Facebook thinking about. So it recognizes that you don't have to be 18 to consent to data processing. For example, a 17-year-old should be able to communicate online without her parents' permission, but at the same time, heightened expectations apply to how a company will handle the data collected from that same 17-year-old. GDPR introduces a concept of organizational accountability, which again doesn't necessarily, if you're not in the data protection world, sound that exciting, but actually is incredibly important, particularly for large organizations, but I think for smaller ones as well, in encouraging thoughtful approaches to data protection and to building accountability and to thinking about data up front. One of the things that GDPR does in requiring data protection impact assessments and other mechanisms is it is essentially saying to a company, before you collect data, before you even necessarily build the thing that will collect data, think about how that data is going to be used, make sure you have a purpose for it, make sure you understand how the data might be misused and that you've guarded against it. And building those mechanisms that force companies to document, again, I think you heard several of the panelists talk about doing that in a scalable way that's appropriate for large companies, and then it's also appropriate for smaller companies, is a really important contribution, and I think is one of the areas where we invested most heavily following GDPR. And finally, there's an idea of strong, robust, and centralized enforcement. One of the big debates going into GDPR was this idea of a one-stop shop. Should there be a central regulator in Europe that can tell a regulated entity what's required, and should they have the kinds of penalties that you heard talked about as a stick to force compliance? And I think on both of those metrics, I think that, those are both important contributions. One, the significance of the penalty is of course important to making sure that companies are paying attention. But equally, having a single regulator that's empowered to tell a company what the law requires, which is also something that's a feature of the proposed law here in India, is really important. One of my most fundamental jobs as a person who thinks about privacy at a large company is to make sure that we're doing our job to meet our legal obligations, but also meet the expectations of the people who use our service. And an important condition to that is that I be able to go to the regulator and say, we're proposing to do this thing, here's how we're approaching it, and the regulator can say, you need to do these other things or you don't. If the regulator isn't empowered to make that judgment, because there may be multiple regulators that will disagree, it's hard to achieve compliance because I won't know until the end of an enforcement procedure what's happening. And so again, making sure that the regulator is empowered to make those judgments is important. Now, there are obviously, GDPR has made those contributions, but I think there are also a number of areas where we still have questions. And Anushka, you sort of alluded to the fact that we're 17 months in at this point, so we don't really have final answers on how successful was GDPR. We don't even have final answers. The European regulators are still in the process of enforcing the regulation. And so some of the questions are around how do we think about these principles when it comes to new technology like artificial intelligence? GDPR has an idea that for automated decision making you have to have transparency and some other controls, but what does that look like in reality? What does that look like for machine learning? How should you be more transparent? We don't have really good examples for what that looks like. The idea of making secondary use of data, there's been a discussion about community data and the idea of taking, here in India, and the idea of making new uses of data that create value for people. And again, GDPR anticipates that this is possible and allows what are called compatible uses in a case where you don't have to go back and get additional consent if the new use is potentially a little bit different but consistent from what's expected. So again, it leaves the door open for that innovation, but again, we don't know yet what that's going to look like or how to know whether a particular use is compatible or not. And then there are other uses of data that potentially are high risk or high sensitivity, but also high value. So for example, there are companies this is something we're thinking about at Facebook, but that also is particularly important. And that other companies are thinking about, for example, using artificial intelligence to identify people who are at risk of self-harm, who are thinking about suicide. So this is something that's very sensitive from a data protection standpoint, also really important to do. And I think we're still working through under a more rigorous regime like GDPR, how those kinds of things should happen. And so, again, we're 17 months in, and I think there's still a lot to be learned, but also a lot of really important precedent that we can build on as we're thinking about global data protection regimes more broadly.
Thank you so much. Well, I think this was an excellent demonstration of how the GDPR really raised a lot more questions than it answered. But this is also symptomatic, of course, of one of the first real attempts at a comprehensive legislation that actually also has a lot of extraterritorial effects, right? And with this, I would like to hand it over to Pauline, who is a distinguished researcher with a very broad portfolio, based here in Asia as well, and I think who can provide a very interesting perspective as to what impact the GDPR had beyond the borders of the EU.
Minasan konnichiwa, Reich to moshimasu. Do you know what language I'm speaking? Thank you. Okay. I was a professor at Waseda University School of Law in Tokyo for 22 years, so I've been living mostly in Asia. And I moved to Singapore. I'm at the Rajanatram School of International Studies Center of Excellence for National Security at Nanyang Technological University. I don't know if anybody else has to give out all of this in saying where they work. But anyway, that's where I work now. Since November, I've been in Singapore. And so I'm an Asianist, basically. I was on the Committee on Asian Law of the Association for Asian Studies way, way back. And I've been in love with India since 1970 when I first came here. Long story, ask me later. Anyway, so I've been following India for a long time. I've been living in Japan. And I founded the Asia Pacific Cyber Law, Cybercrime, and Internet Security Research Institute in Japan. I'm also general editor of the law treatise Cybercrime and Security, which covers the whole world, and it's published by Thomson Reuters, and it's too heavy to carry. It's 3 volumes, 3,000 pages. I update quarterly. But I am on top of developments, and more, in addition to the cybercrime and cybersecurity material, I've had to add privacy because it's become so important. I do feel that GDPR is setting a good high standard for the world. And okay, so you're in Asia. Why should you be bothered with a European piece of legislation? Well, I'm seeing the impact or the influence of GDPR because countries in this region are adopting privacy laws, and they're updating because they want to be seen as top places in this whole cyber world. So I'm going to give you some examples of the region with dates. Japan amended the Act on Protection of Personal Information, which came into force in 2017. China's new cybersecurity law came into effect in June 2017. Now, both of those countries are in my law treatise, Cybercrime and Security. We're about to publish the update of the China chapter with English translations of the Chinese laws. It'll be out in the new year, and it's available on Westlaw. If you're lawyers, you can get it in digital form. Australia introduced a mandatory data breach notification scheme on the 22nd of February 2018. And let's see, who else? Vietnam passed a new cybersecurity law that will come into operation on January 1st this year. It came into operation. I'm trying to obtain a translation in English and hopefully we'll publish it. Thailand's personal data protection bill was expected to be enacted in the near future. This is from a law firm that's based in Hong Kong. Now, Hong Kong was considered the absolute leader in the region until recently. And Alan Chung, who's the former privacy commissioner, was with me at a program recently in Singapore. And he's out, and things are slowing down in Hong Kong, where they were the leader, and there's a privacy organization, kind of a commercial one, that met in Hong Kong. I was there and went to their program a few years ago. But Hong Kong seems to be slowing down, and of course we know what's going on in Hong Kong right now. So we're just not sure where things are going. Now, the Philippines likes to be on top of things, likes to look good, and so they actually had a Data Privacy Act in 2012. And they established a National Privacy Commission, and that monitors and enforces the law. And in September 2016, the National Privacy Commission released final rules and regulations for data implementation, mandating companies to register as personal data processing systems by September 9th, 2017. So that's a little sampling of what's around in Asia. I think Malaysia has legislation, certainly Singapore does, and everybody wants to be seen as responsive to GDPR, as being up and running. Now, I will not comment about Cambodia, but I'm in a group with Cambodia. It's called the Regional Asia Information Security Exchange. We're meeting in Tokyo next month, and I'll have to check with my friend who does a lot of the stuff in Cambodia. There are very few people in Cambodia who are doing the law and policy work, and this man has been in our group for quite a while. I've been in that group for 18 years. Okay, so you see what's going on in our region. Now, there's something called an adequacy decision in the GDPR, and you need to know about that because they are reviewing the legislation of the various countries, and they're determining who's falling into line, whose law fits with GDPR. Does anybody know which country in this region it has received a positive adequacy? You're not allowed to say a positive adequacy decision. Anybody want to volunteer? Who? You're right. Okay. So Japan has been viewed as adequate. They're very secretive. I'll tell you a fast story. I had an account with Citibank Japan. I said, could you send me a copy of my statement? No, that's privacy. You can't, wait a minute, it's my data. We own it now. And this is the difference between American privacy law and Japanese privacy law. So the notion is rather cultural, and it's rather secretive in Japan. And it's very hard sometimes to get new Japanese legislation in English because it's published in Japanese, and it takes a few years for a government website to produce the official translation. So, but anyway, Japan's in good shape, and Korea is being considered. They're being reviewed. So that's, you know, where we are in the region, but most countries want to be up there, and part of the GDPR, I would say, initiative for the world. So that's where we are. Now, if you get an adequacy decision, why is this good? It would benefit all the companies in your country. So that means the companies don't have to spend a lot for legal fees. They just, your country's in good shape. So that's one benefit for getting an adequacy decision. So that's the last point in my introduction is who's getting fined, because there are fines under the GDPR, and that's one of those open questions. Are there going to be fines against countries in Asia? The big fines that we've seen, British Airways, Marriott, and Google. So they're going to get to the Asian companies and fine them, and that might be, you know, a negative reason for you to have legislation.
Thank you so much, Pauline. I think this was an excellent survey also of how other countries have responded to the GDPR. And I think one interesting question to raise later on in the discussion as well is to what extent have there been innovative alternative or additional approaches to the GDPR, right? Because the GDPR is obviously a comprehensive first attempt to try and regulate this new world that we're living in, which does look very different from the time when the EU directive was first passed in 1995, right? But the GDPR is also not the end of the data protection story, it's more the beginning. And I think there's also a lot of opportunity for additional and perhaps more locally sensitive approaches to privacy regulation as well, and I'd be curious to learn more about that. But before we do so, last but certainly not least, we have the great pleasure of being joined today also by Ambassador Pearson, who can provide some introductory remarks with regards to the position of another, unfortunately, about to be third country to the EU, the United Kingdom. So thank you so much, Ambassador Pearson.
Thank you. As you've gathered, I'm the UK Cybersecurity Ambassador. I'm primarily involved in purely cybersecurity aspects, but obviously I speak when asked to on a range of information-related stuff. I was just musing that in the last job before I had, when I was providing support to our Ministry of Defence, I was actually working in the department that had policy responsibility for data protection and indeed for freedom of information requests. As we've already heard, the UK passed into law the first Data Protection Act in 1998, and actually, so there's a long history right across the EU in handling these things. And actually, I personally was involved in a major case of a loss of a laptop which contained the data. It turned out in the end of about 1.4 million UK citizens, most of whom were applying to join the Royal Navy, but actually many of their relatives' details, some cases quite personal details, were on that. And that was actually, I mean, this is way back, we're talking, I can't remember when it was, 2007, I guess. It was actually a major case. We didn't have fines, but the government was certainly very much, we actually had to have a independent inquiry into what had happened, and we were seriously censured by the Information Commissioner. So a bit of a digression there. As you all know, the UK has implemented GDPR and through our own Data Protection Act in 2018. So it's in UK law, independent of our membership of the EU or not. We would argue that we've been a global leader on data protection standards, and we will continue to be so as we leave the EU. And if you look at it, you can see that the UK had a very strong hand in the actual drafting of the GDPR itself. So no change there. Our fundamental position, though, is that the ability to transfer data across borders is really crucial for a well-functioning modern economy. So when data can't flow, it represents significant barriers to trade. So we are very committed to international data flows, underpinned, though, by appropriate data protection standards. And this is all about finding ways to safeguard privacy while promoting innovation. And it's crucial to do this to fully, as I've said, to fully realise the opportunities of a data economy. For the moment, we believe that GDPR is a good basis for doing that. We also took the opportunity in the UK, when the Data Protection Act was passed, to significantly strengthen our information commissioners, so our regulators, the enforcement tools that the Information Commissioner had, including powers to carry out urgent assessments of organisations' processing activities, often used after a breach. And so this is why the Information Commissioner, in cases like British Airways, has actually gone in and worked out what has actually happened. Yes, the British Airways was fined, the largest fine to date under GDPR, and that was as a result of the assessment by the Information Commissioner of the state of play in the company. So that's all I want to say by way of starting out.
Excellent. Thank you so much, Ambassador Pearson. This concludes our introductory round of remarks. I'll do a lightning round sort of questions to different panelists to further delve into some of the topics that we touched upon. But I will make sure also that we have at least 15 minutes at the end of the session for audience members to also ask their questions. But perhaps to kick things off, I imagine that it might be interesting to a lot of us to learn more as to what GDPR implementation actually looks like in practice under the hood, right? So perhaps we can start things off with Rob, who can perhaps explain a little bit, okay, like what did implementing and does the ongoing implementation of the GDPR look like at Facebook? Some lessons learned, what were some challenges, surprises? I'd be curious to hear your views. But all responses from now, and please keep yourself short so we can enable room for discussion. Thank you.
Yep, absolutely. So one thing I should say is that in addition to having a Facebook entity here in India and one in the US, we have for many years had a Facebook entity in Europe. So even before GDPR was passed, we were doing a lot of work to comply with the directive and the existing data protection law. So we weren't starting from scratch, but that said, it did involve a very significant investment of people and time and resources and planning to achieve GDPR compliance. I think we probably had more than 300 people across the company working just full-time or nearly full-time on GDPR. And that included lawyers and policy managers building data protection impact assessments and engineers and lots of other things. But as a part of our GDPR compliance, there was an organizational accountability component of mapping data flows and identifying processing purposes for them and those sorts of things. But from a consumer standpoint, a lot of what people saw was, for the first time in a long time, not just Facebook, but lots of companies were talking to them directly about privacy. And so if you were on Facebook in mid-2018, you saw everybody at least once, and for many people a couple of times during the year, we communicated with them about privacy, let them know how their information was being used, and asked them to make choices about various aspects of how their information is used. Things like what their advertising experience looks like, or whether we use certain data as a part of their experience, or how they work with apps, these kinds of things, and prompting people. So these are sort of the most salient privacy choices you have on Facebook. We also built a centralized center that anyone can go to centralize these choices, so that you can find all of the most important privacy choices all in one place. And then, as I mentioned earlier, one of the big components of GDPR is the ability to access and port the information that you've provided. And so we put a lot of resources into building out a feature called Download Your Information, and another one called Access Your Information, that lets people see the information we have about them. And again, it seems pretty simple, but in many countries, you just don't have the ability or the right to see what information companies hold about them. And so, getting to the place where we were centralizing all of that information in one place and making it accessible was actually a pretty big engineering challenge. But that was also one of the things that we invested a lot in. And so, importantly, across all of these different efforts, we had a lot of people working on it and those sorts of things, but we made a decision that when we were building these privacy protections and these privacy tools for people in Europe under GDPR, we'd make those available globally. So if you're somebody in India who's on Facebook, that you have the ability to get access to your information, you have the ability to request that it be deleted, all of the data protection planning and infrastructure and those kinds of changes that we did all apply because we thought that they were important steps to take. Now, I think it's one of the criticisms that people have made of GDPR is it takes a lot of work and it takes a lot of documentation and a lot of planning, and so I think one of the challenges is figuring out how to scale the kind of work that we had to do so that a smaller entity would be able to achieve it. And I think a lot of folks probably on this panel and around the room have been thinking about those kinds of challenges. And then I think I mentioned in my introduction, and I think this is something that we're still working on. I don't think that GDPR work will ever be done. We're also doing work to comply with other national laws and requirements too. And so we have, we just had an order with an agreement with the FTC in the US that's being implemented, and so we're doing a bunch of work there. So it's a continued investment. And I think, as I said in my introduction, the challenge is that the answers there's never going to be a point where we have all of the answers and we've built everything. And so it's a continued discussion with regulators and with stakeholders to make sure that we're making the right choices and being thoughtful.
Thank you. I thought it was a really interesting insight into what it looks like doing this in the nitty-gritty and on the ground. But I think you also raised an interesting point, and with that I'd actually like to return to Gosha with regards to the impact on perhaps smaller businesses. Gosha, you mentioned this might be a myth, that there might be a disparate impact on smaller and medium-sized businesses, but an often forgotten aspect about the GDPR, I think, is that the law aimed to enable the protection of personal data, but also to enable the free flow of such data, right? The EU at heart is a union that is supposed to also improve trade across borders, right? We've talked a lot about the fundamental rights protections of the GDPR, but perhaps, Gosha, you could share some impressions with regards to how successfully GDPR has facilitated trade, and perhaps how we can also build upon the GDPR to make sure that this free flow of data is also enabled within the security protections.
Thank you very much indeed for this question. I can tell you, let's say one case. We got once a question from Malaysia, if I'm not mistaken, from a small company, and they said, well, we had like 2 companies who has like a few contacts with the EU. And then what shall we do? They were like scared because about this, what I wanted to tell you about the cases and these penalties, I think what also Rob mentioned, it's like one thing is actually to penalize the breach, but the second maybe more important role of all penalties is from, I think, philosophy of law, to scare or like threat potential others eager to, misbehave. So we discuss with them and we say, okay, like for the scale of your business, you will not be penalized like with millions of euros, so like don't worry. So we have to always balance, the grievance. And maybe when we talk about the assessment of the GDPR, even in the regulation itself, the Commission would need to present the report to the Council, which is one of the EU institutions composed with the EU member states, like really governments, presenting their national interests by May 2020. So they have 2 years for a proper assessment how it's implemented. And so far, until the summer, almost all member states implemented, because one thing, once the EU legislation is adopted, usually first it's like between 6 and 24 months for member states, for authorities to transpose the legislation to their national legislation, and then the companies have also their, like, let's say, deadlines to comply. So there would be 2 years after the transposition. But so far, it was already a very interesting report published in July about this assessment. So the basic outcome or the main findings are that indeed the General Data Protection Regulation shows results, but work needs still to continue. So we say it's like a baby project. It's in infancy. We have many workshops. We talk to stakeholders, to member states, to regulators at the national level. You also mentioned let's say, the role of the European regulator, which is European Data Protection Board. It's a kind of it strengthens the EU regulator, because so far in the old directive from 1995 we had, of course, national data protection officers, and now it's more harmonized at the EU level. So I would say this is another one. Business is complying. Of course, they complain that it was the same with roaming. Citizens were very happy because prices have decreased, but companies, telecom operators, not so much. So I think with GDPR it's a bit similar. And when we discuss trade, it's maybe the last point, yes, my favorite, it's my favorite topic. Apart from adequacy decisions, we have 11, so also the Commission is reviewing, but we have also advanced negotiations with Korea, and we see there is also another platform. You can see, okay, formally it's adequacy decision, but we might have different channels. So we work a lot with other countries at the WTO level, World Trade Organization, because there is also the ongoing reform on e-commerce. And then data flows is very, I would say, sensitive, and I've observed it many times. There is always a conflict, like me even representing the trade and economic perspective. We tend to be more liberal, let's say open. We want trade data, okay, not trade data, but facilitate the flow, because especially now with digital economy it's a must. But there are clashes with privacy people and more like justice, like really citizen customer organizations, and it's similar at the WTO. We have different working groups, one on trade, one on privacy. So let's see the outcome. And maybe the last point from my trade experience, from trade negotiations, even within the free trade agreement, we observed even from Indonesia. One colleague is here, maybe you want to comment. We had a chapter on data flows, and Indonesia was very open. Of course, you have also your own legislation on I think 3 levels of data and the sensitivity of data. But Indonesia told us, okay, we don't have this legislation, but we want to have. And it was like, again, the trigger. So if I may maybe end up this note, it's, I know that Brazil, Chile is also interested, and like other countries all over the world. So that's maybe my main remark for now. Thank you.
Thank you. And that's also like a nice transition, I think, with which I would like to return to Pauline, from both your personal experience and your academic research. Sometimes the GDPR is criticized also because it has such a broad extraterritorial effect. And because, as you mentioned with the adequacy decisions, that it is so important for third countries to adapt similar legislations to the GDPR to be considered to be having an adequate data protection standard. To what extent do you think it might also be challenging or even inappropriate to force third countries to implement a similar law to the one that the EU proposed? What might be some regional flavors, or do you have any suggestions as to how one could make this a bit more culturally sensitive?
Sure. Well, a number of things. You really have to make a decision if you want to be in compliance with GDPR because you want to trade with the EU. So it's an economic decision for countries also. So it may not be in their interest to trade with the EU. I don't know what the volume of trade is between the respective countries that I mentioned, but that's a consideration, a national interest kind of consideration. Now, there's the new legislation that's also extraterritorial, and that's the CCPA, the California legislation. And we don't know, it's being amended right now, and we don't know what it's going to, there's another question. So what concerns me a bit is what are the other countries going to do? And there's so much red tape, and it's going to be endless work. So is it economically feasible if you're a huge company? I won't mention a huge Indian company that I'm thinking of, but is it feasible to invest in all of this, or should you just not do business with the EU and California? Now, California is the 6th largest economy in the world, so, you know, it might be in your interest to do business. But I think, you know, these are serious considerations for countries. So, but it's going to be it's already a lot of work, a lot of vagueness, we don't know yet what we're going to do with fining countries outside of the EU. We've only seen examples of the US, Google got hit, and not Facebook, and then the two British companies. But think about airlines. Think about people's data held by airlines. And I've also looked at hotel hacks, you know, not only Marriott, but I was following hotel hacks over the past few years. So is it worth it? And I think each country has to make a determination.
Thank you. Yeah, I think that was a really some really valuable points, and also these strategic decisions, right? Like at some point, and I think this is something where we need a lot of more international cooperation as well, right? Because sort of like this unified regulatory landscape is a huge compliance burden on companies. It can lead to conflict of laws on the ground as well, which are in nobody's interest. So having sort of an international agreement as to what the appropriate norm might look like, that remains sensitive though to also like regional economic needs and different levels of economic development, I think is very important. And perhaps at this point I have two last questions, one of course for Anushka and Ambassador Pearson, but then we'll open it up to the audience. Perhaps one question to Ambassador Pearson, since you have obviously extensive experience in your job, requires you to promote cybersecurity practices at home and internationally. What can we learn from your experience in the realm of cybersecurity with regards to international norms on data protection as well, particularly cross-border norms and expertise, since many of these challenges cannot be addressed in one jurisdiction anymore? And you have 2 minutes.
Difficult question to answer. I mean, in terms of cross-border jurisdiction, the world is getting more and more complicated. I was talking at a meeting this morning about situations where data is actually physically held in India. That's where it's stored. It is being processed, in this case, by a UK company in Singapore, and the subjects of that data are Australian. And that is happening all the time. And so if something went wrong, whose jurisdiction is it? And there is, you know, there is a lot that needs to be done to make this work. This is happening now, and so I'm sure there may be some interesting case laws coming up. I think GDPR is actually pretty clear on this. It has extraterritorial scope. And so if you want to do business in the EEA, you must abide by the standards. And even more so, under Article 27, if you're going to offer goods and services from outside to individuals established in the EEA, then you have to appoint an EE-based representative who can be subject to legal penalty at the end of the day. So I'm not sure that clearly getting a clear understanding of levels of cyber security which are acceptable. I mean, when looking at when a breach happens, the degree of culpability, if you like, of the organisation concerned, there has to be a look at how seriously they've tried to meet their obligations, and obviously there is, if they've followed good practice, good cybersecurity practice, then they're in a much better situation if they haven't. So I think there are a lot of unanswered questions here. Sorry, that's not a very satisfactory answer.
No, I think that's great, because raising more questions I think will be great for audience discussion as well. But last but not least, I also want to hand it over to Anushka, who can perhaps also share some of her expertise also in the realm of information security with regards to what we might want to focus on to close the gap between legal specifications, technical implementation, and training users on the ground, because I think both in the realm of cybersecurity and data protection, there's always the challenge of laws written by policymakers, then you have companies and software engineers which have technical expertise and don't speak the same language, and also the importance of users, right? Because you might have the best data protection functionalities available. There's no help if then a user has the password and a post-it on a computer, right? They're like basic practices. It's a very interdisciplinary field, right? So perhaps you have some ideas as to how we can bridge these divides.
Sure. So I think looking at cybersecurity and the GDPR, it's interesting that the conversation on the GDPR has actually been a little removed from cybersecurity and the need to kind of counter threats that emerge in cyberspace. And that's interesting because actually 2 weeks before GDPR's implementation, member states had to successfully transpose the NIS directive, which looks at making critical infrastructure services and providers sort of more resilient, 2 weeks before that. And yet we see that most of the policy discussions and discourses tend to be about GDPR being this kind of revolutionary regulation and not as much focus on the NIS directive or cybersecurity. I think the principles are the same or similar. The underpinning concepts in both of these regulations, it's about accountability, it's about trust. And I think from what I can see as a researcher, and I'm looking at the EU bodies and the regulations that they're coming out with, they're addressing the fundamental pieces that ultimately will lead to a more sort of cyber resilient society. So data protection is one on the one end, and NIS directive, which looks at cyber. So in that sense, I do think that I want to make a point that the EU is taking the right direction. To the extent that, and because I'm comparing these, I don't know to what extent I can say the NIS directive is sort of less challenging to implement than GDPR. I don't think that's fair, and I don't think we can make that kind of assessment or comparison currently. On the point about what we can do, it's between technical implementation, legal, it's interesting because I work in the field of cybersecurity, but I'm not approaching this from the perspective of a lawyer or an engineer. I'm approaching this from the perspective of policy. So a lot of the times, and in almost like 90% of discussions that I've had in my field, it's always been, oh, the policy side is not talking to the tech side, is not talking to the legal side. This is something, it's universal, it's not something Europe grapples with, it's not something the US grapples with. I wish I had a grand all sort of solution for this. I do think capacity building is the right kind of way. First is capacity building because you've seen it in the country that my think tank operates in. I'll give you a quick example. So we recently published the Cyber Readiness Index, which essentially looks at gauging how cyber ready a nation is, and we applied it to Slovakia. And while we were doing this, what was interesting is, and this is perhaps because it's a small country, but a lot of these different interdisciplinary groups sort of came together to work on this report. So I was talking about it from the policy side, but there was a lot of legal expertise. There were a lot of actual engineers and civil and critical infrastructure providers who actually gave us important input that led to that particular report. I don't think these conversations, and again, this is probably a cliche and you've heard it 100 times, so I'm sorry to say it 101st time, but essentially, you can't have these kind of conversations in silos. So which is also why this has been a very good learning experience, because I've heard perspectives from different kinds of groups. And as you can probably tell, I'm obviously a fan of the Internet Governance Forum model. But yeah, I'll end it there.
No, but I must clarify that cybersecurity is the competence of that member state.
Yeah,
No, but it's maybe also replies to your question. We don't have the EU cooperation as such, or not
Yeah.
yet.
Yeah. So I think there was a point of clarification that cybersecurity remains within the competency of the member states. Yeah.
There's one other point I wanted to mention.
But very, very briefly, because we do want to enable the audience to participate. Is that okay, Pauline?
Well, just one quick
Yeah.
thing. When they do the adequacy review, they look at cybersecurity within the country that they're considering for adequacy. So they are looking at both.
Yeah,
and
yeah.
that's
Information security is also an aspect of the GDPR. But with that, we do have around 10 minutes for questions. So if you could raise your arms high so I can see you. I will take a round. I can see 6 already. One question each. A question is a sentence that ends with a question mark. It's not a paragraph, it's not a story, it is one sentence with a question mark. Please direct it to one of the panelists. We'll start over here.
Hello everyone, myself Asit Gupta and I am 4th year law student. And my question is to Mr. Rob. I want to know that how GDPR has affected the artificial intelligence thing in Facebook, because it clearly restricts the collection of data, how the automatic decision making is done and all.
It's a really good question, and I think
Rob, and my apologies, I think we might do a round in the
Of
middle of
course.
closing statements.
Please.
Yeah, thank you. And thank you for this great example of what a question is. Here you go.
My question is, the Indian government is floated a concept of monetization of data. Now, in view of the data being monetized, I would say illegally by some private unscrupulous elements, and the so-called government initiative of monetization of data, obviously we presume it will be with consent and it will be done in a very, very, I would say, above board manner. But then any panelist can answer about the perspective of how different government is from a private player if they are deciding to monetize the data that they own. Thank you.
Thank you. So interesting question of the role of the government in this as well. Go further down the line, I think we have...
Yes, aside from the adequacy status, the GDPR says you can transfer data using BCRs or other derogations. And Article 42 states that there's a possibility of having a European data protection seal, so that a company within a country that has the EDPS would be allowed to accept cross-border data transfers. So any updates on that would be welcome. Thank you.
Perfect. So, DF certification. Then Mega.
Given all the conversation we've had at Sci-Fi around global standards and harmonization, I'm curious to hear thoughts from, I'm going to say Rob's name, but if anyone has insights here, about, so if you think from the implementation side, how much of that you want to harmonize, and then the added burden that comes in form of accountability and transparency, how does a company like Facebook would think about that?
Thank you. Further down the line, I think we have this gentleman over here.
Yeah, so due to the extraterritorial scope of GDPR, I just wanted to know how Facebook, did Facebook foresee or did it face any challenges in complying with, let's say, GDPR in as well as national data laws across the world? And does Facebook see the world shifting towards a nationalistic data privacy laws affecting its ability to operate independently in different countries?
Excellent question as well. Yeah.
Question for Rob. I know this is about the EU GDPR, this panel, but I wanted to know about Facebook's experience with the EU regulation on non-personal data that also kicked in this year.
Any further questions on this side of the panel? Did you have one? Okay. In this case, I will allow the panelists, we have 7 minutes left, which means 1 minute and like a couple seconds to answer any question that seems particularly pertinent to you. Perhaps we'll start with Ambassador Pearson, we'll go down the round.
Okay, well, I'll make a stab at answering the question about monetization of data. As far as the UK government is concerned, if that data identifies the subject of the data, then it's subject to the GDPR, Data Protection Act. There's a more complicated case where if you effectively anonymize the data, then it may be possible to, and where there is benefit to society in doing so, then you can look at ways of monetizing it, but it has to be for the, there has to be a benefit from that, I think. Is that? It's okay, I'll look at my policy advisor on the left. Is that a reasonable answer, Sebastian? Yeah. I mean, it's a complicated issue. I mean, the particular case I'm thinking of is where large numbers of individuals' health records are made available, but in a very anonymized way. And so the data is actually sold by the British Health Service effectively to companies who want to use that data to research for what will in the end up with better healthcare. They make some money along the way. But
just a clarification, Mika, was that question for me or Facebook? Because you started with, I think, addressing it to me, and then you said what a company like Facebook would do. Was that, so not for, just clarifying.
I think there's a more generic part to the question, which is around harmonization and global standards aspect of the implementation bit of GDPR. But because the initial conversation around implementation is something Rob addressed, I wanted him to also think about how if that would basically mean increased accountability for a company like Facebook, they have to also share how they're implementing GDPR, so how he thinks about it.
Okay, sorry, I heard GLOBSEC instead of Facebook. No, but actually on that point, if I could just make a quick comment anyway, just on the implementation, because when I was studying GDPR and when I'm looking at it from the policy perspective, you're looking at it as an outsider, right? So what kind of policies should be implemented and things like that. Interestingly enough, one of the questions I think that Paula shared with us before the panel was that what challenges did you face while implementing GDPR? And I think that really made me think, because so the forum that we conduct, it's 1,200 people. We have about 65 to 70 people in this organization. We have data from, just like any other think tank, we have data from across the world. I have to be honest, and I hope everybody will just keep this a secret, we were struggling. And we are still one of the biggest think tanks in that space. We were still struggling until a few days before GDPR was actually being enforced as to what do we need to do differently. How something as simple as the newsletters that we're sending out from all of our research programs, does something change? How does our website change? All of these problems. So I wanted to mention the challenges that we also face, not just from looking at GDPR policy as an outsider, but actually in your own roles as government, as think tanks, and what kind of challenges you face in implementing it. Thank you.
I appreciate the speeding up. We have 1 minute each. Please keep this in mind as you do your closing remarks. Thank you.
Okay, so actually I agree with gentlemen about the data transmission, cross-border data transmission. Apart from adequacy decisions, we have also another, let's say, instrument. So first, the data transfer must be legal itself, of course, and then which is based on the voluntary consent, right? And then if the intended data transfer meets the general requirements, one must check in a second step whether transfer to the third country is permitted. And for this, we have these adequacy decisions. But even if we do not have them, if there is no adequacy decision for a country, this doesn't necessarily foreclose the data transfer. And as you rightly mentioned, there are several exceptions, and then bilaterally entities decide. For instance, they add the they add so-called binding corporate rules on the voluntary basis through the commitment to comply with codes of conduct, which have been declared by the European Commission. So as you say, there is always the solution. We don't like problems. We prefer solutions. But if you agree, maybe if I can assist you on this non-personal data. Please. So if any of you is concerned about the GDPR, there is always non-personal free flow of data regulation from November 2018. And of course, GDPR affects all of us as individuals, right? Like our personality, personality as well, but our privacy. However, I would say the younger sister, the non-personal data, it's actually to facilitate the trade, the commercial, the industry. And then the idea is more about collecting industrial data on like servers. So for instance, shall the German Siemens shall keep all the commercial data in Germany or like, in Munich or, so this kind of, attitude. And then the European Commission has identified 4 types of possible obstacles, which are now being sorted under this piece of legislation.
And perhaps you can go into further detail also after the panel.
I will just maybe this is 4.
Just because we have a time constraint, we want to give the other panelists.
So data localization restrictions by member states, public authorities, obstacles to movement of data across IT systems, so-called vendor lock-in, legal uncertainty leading to caution on the market regarding cross-border data storage and processing, and then lack of trust due to security risk and concerns about the cross-border availability of data for regulatory purposes. So even there were like discussions inside the EU, shall we have this legislation as well? So to bring it to the even more non-EU level beyond the EU, I think that's the future, but I think that's coming. If you, as business representative, if you agree.
Yeah, absolutely. So I'll just very quickly address, I think a number of the questions to me were around how do you deal with this as it's not just GDPR, but as you have lots of privacy regulations in lots of places. And I think it's a real challenge, and I'm glad actually to hear the group raise it. When we have regulations that are high level and that have principles, as I said, we apply the principles of GDPR globally, and so the protections that people in Europe have under GDPR apply in India and around the world. The challenge becomes what happens when those are more formalistic, right? When it's the kinds of documentation that you have to do, or the kinds of consent that you have to get, or it has to look different in different jurisdictions. This becomes really challenging both to operationalize globally, but also it becomes challenging when you have different sets of obligations that might apply in the same situation. And so there have been a bunch of efforts, both formal legal frameworks and voluntary frameworks to address these. So the APEC cross-border privacy rules are an example of a voluntary framework that member economies can participate in. And basically each nation has its own laws, but they agree, here are some top-level principles that we're going to agree are the building blocks for a company who's going to comply with privacy regulation across the board. I think that's good for companies. It's also good for for states that are participating in it, because they get more due attention to the standards that they apply. The OECD, I think one of the questions was around artificial intelligence. The OECD just came out with a set of voluntary standards around how to do privacy and fairness and these kinds of things well in the context of artificial intelligence. This is another mechanism to enable companies like Facebook to do one thing and do it globally, and also to make sure that it's done to a high level of protection. And then finally, I'll just turn to personal data, non-personal data very quickly. I think you did a good job of explaining sort of what the discussion is in Europe. We've been spending a lot of time at Facebook thinking about how non-personal data can be used for the benefit of society, things like tracking the aggregate movement of populations in the event of natural disasters, so disaster response organizations can deploy in those areas, or tracking the spread of misinformation about health issues, so that health education organizations can target the information in a responsive way to the communities that need it the most. So these things are really valuable. I think one of the things you talked about is anonymization and de-identification. There's always a theoretical risk of re-identification, and so the idea of releasing data sets becomes really challenging when we don't have robust technology to de-identify, and when we don't have standards for what's the right way to do it. And so I think there's real promise there, and as our investment has shown, there's real promise, but I think we also need to do a bunch of technical and policy work to create some standards around it.
Yeah, thank you. And again, all panelists obviously will also be available later to further address the question beyond the 15-second question time span. Finally, Pauline, some closing remarks, hopefully uplifting. Thank you so much. Well, if that is the closing statement, again, we are all around after the panel as well. Please join me in thanking the panelists. I think our main takeaway is obviously that the GDPR is more interesting than Beyonce. So with that, enjoy the rest of your day.